Advocate is joining us on the broadcast to give his take on this. Mr. Luthra, I hope you can hear me, sir. Thank you for joining us and speaking with NewsX. Your initial reactions to the verdict in this case. Of course, the quantum of punishment is going to be coming forth on Monday at 12:30 p.m.
Right. So just to tell you, this is the first stage of any conviction process where the conviction has happened, as you have informed your viewers, that it's happened for specific offences for which he was charged. The sentencing is the second aspect, and that is yet to be determined. That's based on the individual circumstances and the circumstances of the crime, both. So that exercise is yet to take place. Of course, we must keep in mind that despite this being the conviction today, he has the right of appeal to the High Court, and thereafter a possible challenge in the Supreme Court, depending on what the outcome in the High Court is. So the only thing which we have to note is that this is one of those trials which has taken place at fairly fast speed, and for that we must acknowledge the fact that there has been the court has acted with expedition, as it should act in every case, not just high-profile cases, as also the fact that there has been a effective prosecution, though I understand that the trial court judges passed some observations regarding the investigation, as also the conduct of the superintendent and the other establishment members of the hospital. So that's my take on it.
And Mr. Luthra, this is also an important case. When I say important, I meant in terms of the kind of pressures that were seen politically as well as socially in making sure that justice is served. How do you react to that?
So I'll tell you what, it works both ways. In this case, there are pressures which have, political and social pressures which have worked in a certain way, and there is a conviction. But we must also keep in mind that there is, to every accused, however heinous the crime may be, there is a presumption of innocence at the beginning of the trial. Today, of course, that presumption has been rebutted by a conviction, but that is always a presumption. And therefore, I always say this, that we should not, our system should reach a level of fairness where we do not need extraneous pressures to ensure that the cause of justice is served.
Mr. Luthra, how does this create a deterrent for future transgressors when it comes to rape and murder? There have been such gruesome crimes in the past as well. They really haven't deterred people from committing such crimes, and of course the lengthiness of the justice system has also contributed towards the apathy in the system. Do you think that this was an expeditious decision, and perhaps the delay that we see in most cases was not found in this one?
Yes, of course, this was an expeditious decision, and there was no delay. In fact, I will tell you, let's go back to the Nirbhaya trial. In the Nirbhaya trial, you know what happened. Matter went to the Supreme Court, and in 2017, the 2012 incident culminated in 2017 with an affirmation of the death sentence by the Supreme Court. Having said that, eventually, we must understand our social structures are such that crime is going to happen in any society. It's not just about India, but anywhere in the world. What we have to work at is at effective, preventive, scientific policing. Till that happens, you will not be able to reduce the amount of crime. Crime cannot be extinguished. That is unfortunately one aberrant part of human nature. But we must work at through education. If you look at the Nirbhaya case, Justice Bhanumati's opinion, she said, look, you have to start counseling and educating children from school so that you sensitize them to what is ethically correct, what is not, what is legally correct, what is not. We are not doing that as a society. That has to begin at school and as also at the home. And once we do that exercise and we have effective preventive policing, we have effective investigation, you will ensure that crimes don't happen. The third part you already addressed, that there should be effective prosecution, expeditious prosecutions in a Nirbhaya case or an RG car are those exceptional cases where prosecutions have happened at, if I may say, breakneck speed, which should be the normal course in all such cases.
Mr. Luthra, what happens now? Of course, we all know there is a chronology of appeals that is going to be followed through. Is that also a dampener in such cases? Because obviously, all of these appeals do take an exhaustive amount of time.
So again, there is a divergence on that because, as I said, Nirbhaya happened between 12 to 17, everything was over. Similarly, this case you had a trial which has gone very expeditious. The Code of Criminal Procedure, the BNSS as it's now restructured, talks about a day-to-day trial. We have to achieve that ideal. Which there's only Kerala which does it, other states don't have it, but we have to achieve that ideal, number one. Number two, there is first going to be a sentencing process. Only once the sentencing process is clear will we move to the next stage, which is the appellate process. So till the sentencing is done, which should be done shortly whenever the court determines it, thereafter, if the sentence is not to the satisfaction of the prosecution of the victims, there will be a challenge. If it is to their satisfaction, let us say it's the maximum sentence, then there will be no challenge by the state, but the accused definitely has a right to a challenge. In the event of a death sentence, there will be a reference made and the High Court will have to decide, two judges of the High Court will have to decide whether it's a fit case for death or not, or life, or even if the conviction is valid. So that's an exercise which is yet to take place, and that exercise should take place at the at the High Court level. After the High Court, depending on the outcome, there is a challenge by way of an SLP which is not an appeal. But if there is merit, if either of the parties can point out that there is a flaw in the High Court decision or in the trial court decision which has not been corrected by the High Court, then you can have a special petition which will then become an appeal. So that is the legal position.
Mr. Luthra, appreciate you joining us. Thank you so much. All right, some breaking news coming in. Well, the victim's father broke down in